The Eighth Amendment states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Like other constitutional provisions, though, the prohibitions against cruel and unusual punishment cry out for interpretation. Sorry to be so dramatic. What is cruel? What is unusual? In Supreme Court jurisprudence and in popular commentary, the Eighth Amendment is the subject of very different modes or approaches to the interpretation of the Constitution. Should we fill in the blanks of what cruel and unusual means by repairing to purported ideas of what those who ratified the Constitution meant by those terms? And if we do, whose understandings should be binding? After all, there isn't a footnote after the Eighth Amendment that points us to a ready-made definition that cites a founding father for its legitimacy. Or should we, as Justice William Brennan advocated, understand the clause in relation to the evolving standards of decency that mark the progress of a maturing society? These are not easy questions, especially considering the potential cruelty that could be inflicted upon individuals, but most importantly, because an interpretation of the Eighth Amendment with respect to the death penalty is a final decision. There's no going back and undoing the death penalty. These concerns are only compounded by the increase in prisoners freed from death row with developments in forensic science, especially DNA. Although there are many punishments carried out by the state that implicate the Eighth Amendment, not the least of which are punishments of excessive bail and disproportionate sentences for crimes, this week we'll look at the challenges to the amendment in the area of the death penalty, a punishment which the United States still chooses, even though every other country in the Western world has abolished it, putting it in a category with nations such as North Korea, Iran, Yemen, and Afghanistan, to name a few. The most relevant origins for the Eighth Amendment are in 16th century England, where ecclesiastical courts routinely punished, tortured, and put to death heretics and religious dissenters. As a result, the English Bill of Rights in 1689 explicitly banned the use of cruel and unusual punishments. Although our discussion this week is limited to Eighth Amendment challenges to the imposition of the death penalty, we have to understand that the understanding of cruel and unusual, even in 16th century England, cast a wide net as to which types of governmental punishments might fall under the category of cruel and unusual. So the ban on them can include the actual practices of punishments, a ban on torture however defined, and to disproportionate sentences, like the imposition of 20 years imprisonment for shoplifting, as well as some types of automatic punishments, like the 3 strikes you're out sentencing guidelines. And it also extends to sentences and punishments that are not specifically authorized by the state. The death penalty cases that we'll study begin to come to the court in the 1970s. But interestingly, before then, the court was rarely asked to intervene and give a consistent answer to the question, what is cruel and unusual punishment? But on the few occasions that they did, 2 themes emerge. The first was that the word cruel, not the word unusual, should be the court's inquiry. So, for example, the court early upheld the use of a new or novel way to execute people, electrocution. It was therefore novel, not unusual. The court was more concerned with understanding the word cruel, especially as it related to torture. The second theme that the pre-1970s courts emphasized was disproportionate sentences could violate the cruel and unusual punishment clause. In Trop v. Dulles in 1958, for example, the court ruled that stripping the citizenship of a military serviceman who was convicted of desertion was cruel and unusual because it was disproportionate to the violation. The arc of the cases we'll read this week moved from the court's effective ban on the death penalty in the early 1970s to the court's subsequent approval of it after states changed fundamental aspects of the way death penalty trials were carried out in the United States, especially the development of bifurcated trials, where one jury would hear a case and determine guilt, and another jury or judge would impose punishment. Other related procedures that we'll look at in death penalty cases is whether and to what extent mitigating factors can be used to determine whether a defendant is death penalty eligible. We'll also see how the court handles statistical evidence that suggests that African Americans disproportionately receive death sentences. We'll also look at arguments about whether the death penalty can be applied to minors, the mentally challenged, and whether certain crimes that fall short of murder can trigger the death penalty automatically, like child rape. These are tough cases to read and think about. What's at stake in these decisions are not only varying academic and theoretical pronouncements of what the Eighth Amendment cruel and unusual punishment clause means, but actual lives. So as you make your way through these cases, I want you to think about a few things. How should we interpret the cruel and unusual punishment clause? Should we rely upon 18th century notions, or should we, as Justice Brennan did, repair to evolving standards of what might count as cruel and unusual punishments? If we accept the death penalty as constitutional, in other words, as not violating the Eighth Amendment, how should we deal with the existence of social science data that suggests the death penalty is applied disproportionately based on race? And how should we make sense of the increasing amount of men and women who have been found innocent through DNA tests? Should we execute the mentally challenged? And finally, should we understand the death penalty as a deterrent or a punishment, or both?